let's just quickly discuss the Chapter 7 process from beginning to end. Basically, the way that works is you file a case. When the attorney presses go, files it electronically with the court system, you instantly get a case number. You are in bankruptcy. You have the automatic stay. You have that cocoon of protection. You will find out about 24 to 48 hours later when your court date is. Your court date will be about 5 weeks later. That is called your creditor meeting. You will meet your trustee. Creditors can appear, but rarely do. And there are essentially two things going on in Chapter 7 that debtors sometimes get confused on. One is your ability to get a discharge, and then a completely independent timeline going on at the same time is whether any assets of yours are going to be taken. Because Chapter 7 is a liquidation chapter. I don't know the exact percentages, but probably over 90% of Chapter 7s, even though it is a liquidation chapter, do not see a liquidation. And this is, again, part of the work you need to do on the front end to determine if it's a possibility. But because the main thing you need to know about Chapter 7 is you cannot dismiss voluntarily a Chapter 7 case after you file it. So you can't just dip your toe in the water. So if you think you're at risk of losing an asset, you have got to fully vet that before you file your Chapter 7 case. But essentially, you have your creditor meeting. And then if everything goes according to plan and no creditors objecting or the U.S. trustees not objecting because they think you make too much income or they think you did something fraudulent, essentially nothing bad is going on there, you're going to get a discharge about 90 days after your creditor meeting. And essentially, your creditor meeting would be the one and only court date. I'm going to venture to say 80-90% of the cases, debtors really only appear at that one court date. It might even be over 90%. If you have what we call a no asset case, meaning the trustee does not believe there's anything in an asset or that you gave away to a third party that the trustee can recoup under the bankruptcy laws, the trustee files a no asset report, you will have a case that your assets, because you have no assets that the trustee could recover, when you get your bankruptcy discharge, your case will close at the same time. And that is what typically happens in about, like I said, probably 80 plus, 90 plus % of the cases. The person just files the Chapter 7, has the one court hearing, and gets a discharge about 90 days later, and you're done with it. However, there are instances where either assets are being recouped or a creditor or the U.S. trustee is arguing for some reason against either your total discharge or a discharge of a particular debt, and you may have the case kept open for that reason. And those are the kind of cases I referenced earlier that you may also incur additional attorney's fees. So some of these you can anticipate ahead of time, particularly when you're being upfront and honest with your attorney. The attorney may tell you, look, this one creditor may bother you. They may file an objection. Or the U.S. trustee, you're really tight on the income. They may file an objection. Usually you should know this ahead of time, but this kind of thing can happen in a surprise setting, but usually you can kind of anticipate it, but then the question is, how do you deal with it? So that's typically how a Chapter 7 works. And a Chapter 13,